Good evening,
Yes,
everyone. I, Anushka Srivastav, member of Seminar Committee of Dr. Ram Manohar Lohia, National Law University, welcome you all to today's session. The topic of the session is an overview of trademark infringement in India, and it is a golden opportunity to have Ms. Jyotsna Chikodi with us to discuss this topic. Ma'am did her LLM from Queen Mary University of London, specializing in intellectual property law, and her BBA LLB honors from Christ University, Bangalore. An IP attorney specialized in trademarks, copyright, and patent research with a keen interest in subjects lying at the cusp of law and technology. We are proud to host you, ma'am. One important note for all the participants, please drop in your questions in the chat box. The same will be addressed at the end of the session. Now, without any further delay, I would like to invite Miss Jyotsna. Ma'am, the stage is yours.
Very much thank you for inviting me here with your prestigious law school. I hope today's session will enrich all of you with regards to how trademark law is it with respect to the entire um, law in general, as well as coming to the core topic of trademark infringement as we have uh, scheduled our topic as of today. So I hope I'm audible before I proceed further. Am I audible?
yes, ma'am, you're
Yes,
audible.
ma'am.
All right, all right. Yeah, thank you. So when we start off with trademark law, I mean, when we think of trademark infringement, I would rather, begin with the origin, the evolution part of trademark law, and then I'll come to the later part of trademark infringement in particular. So when we look at origin, we did not have any statutory laws governing trademark law prior to 1940 when the first act of trademarks act of 1940 was enacted. So beforehand it was usually the British India as well as the East India Company that was established here to basically trade off lots of goods or set up a few um, entities itself. We could not call them entities then, but you could see that they had specialized or they were associated with a particular product or merchandise which they were engaged in exclusively. So you could see that a particular product from a particular company, sorry, a, a person engaging in that particular commodity would be would have a goodwill among the people. And you saw that happening prior to the 1940 Act. So the whole concept of trademark, recognizing a product or a name or a logo or the goodwill associated with it started when the market started opening up, and when we see that the whole global market acting on each other with respect to how each country is providing certain commodities or services. When we look at India, we look at spices, we look at cotton, we look at basmati rice, where we are still fighting over the GI with respect to it. So we see that origin from there. And then obviously the Trademarks Act of 1940 was enacted, subsequently the Trade and Merchandise Act of 1956 and the rules associated with it. In order to comply with the TRIPS agreement, the Trademarks Act of 1999, which is now the bare act that we see with amendments being made, and the amendment of 2010, which basically introduced international registration under the Madrid Protocol, where you could where international products or names basically could have a registration within the registry of India, and could have a goodwill here as well. So when I talk about international registrations, I think so many people will talk about well-known trademarks, trans-border reputation, and all such sorts of all such names which are associated internationally. And coming to next, so when we look at what is a trademark in itself, so it's a mark capable of being represented graphically, which is capable of distinguishing the goods or services from one person to the other, and it may include a shape of goods or a logo or a word or combination of colors as well. So there are types of trademark here: product, service, certification, collective, and word marks and sound marks. Um, we are still in the very early ages of sound marks, and there haven't been any smell marks registrations in India. But with respect to sound marks, obviously we know of the ICICI Bank's Yodel and the Yahoo Yodel as well. Um, Also, with respect to the Titan jingle, which has been applied for a registration. So we see a lot of important names, big names that have been associated with a particular product or services in a very, very long time. And they've gathered that goodwill and they've made a market for themselves in a particular jurisdiction or through the entire nation or internationally as well. So you see, trademark is not only the kind of reputation and also the kind of goodwill that you establish, it's also the kind of names or the kind of market you are entering with respect to the goods or services also. So I'm sure all of you must know about what is a product trademark that are used to, usually identifying goods, and certification trademarks are those capable of distinguishing goods or services within which, the course of trade or where it is certified by a proprietor. So word mark is usually like like Walmart or Amazon or Adidas, anything like that. And I've spoken about non-conventional marks such as sound and smell. So when we speak about trade dress, so what is a trade dress? It's a term that refers to the features of a visual appearance of the entire product. It's not only the design or the logo or the color. It's the entire aspect which forms the particular brand is what we call a trade dress, and it is an overall look and an overall feel of the brand. When we look for an for example, McDonald's, you see the M, the yellow color M, as the sign or the logo for McDonald's, where you identify the brand. But when it comes to trade dress, it's not only the M and the word McDonald's. It's also the packaging and the experience you have at that particular eatery. So the all the yellow and the reds, um, and the way the packaging happens, and the way the whole brand is structured in terms of creating a particular market for fast food. So this entire picture will amount to a trade dress. And the requirement of registration for trade dress is the same as registration for a logo or a mark. And I will come to the process of registrations in a few slides. And yeah, one of those very important cases that I wanted to discuss within the 2018 case is the Dabur India versus Vaidyanandram Chamriya. And here, what happened was that the plaintiff launched a variant of the Hajmola tablets with the flavor of the Anardana, um, in a similar container, design, packaging, and everything. So it was stated that the plaintiff proved and the court stated that the defendant had copied the trademark and the trade dress associated with that particular product. And with respect to Cadbury India Limited versus Neeraj Foods as well, it's a 2007 decision. When you see Cadbury's, you picture that purple color or the lilac color, which everybody associates with Cadbury's, and it happens in the same way here, where the Neeraj Food Products launched a gem, popular chocolate by Cadbury, and it was called James Bond. So it violated or infringed their trade dress as well as trademark here. So when we come to well-known trademarks, so what is well-known trademarks? See, our statute is very um, limited in terms of how it has defined well-known trademarks. It says that the mark or a brand or a company that has become so substantial to the public, it has become that any association in terms of goods or services will mean that they are a part of that particular brand. So they have become so big that any product or services that is carried out by another party would amount or would create confusion amongst the public, saying that this particular service or a product would in fact come under their purview. Now, when you see ITC has such a big expansion of products and services, they're into cigarettes, they're into hotels and leisure, they're into clothing, retail, also in terms of home decor. So when you look at such an expansion of market in terms of a product or a brand, they have gathered that well-known status in terms of a well-known trademark track. And anything associated with that particular trademark would amount to confusion in the public. So as 11.6 and 11.9 also say that it protects it confers protection to well-known trademarks at two levels: against registrations of similar marks and against misuse of well-known trademarks. So when you look at the rules of 2017, rule 124 also states that until the rules of 2017 were enacted, it was status of a well-known trademark was gathered or given a status of such by the court itself through a hearing. So when you go to the IP India website, I'm sure all of you know where to do these journal searches and public searches, and the list of prohibited marks or the well-known marks that has already been published by the registry. So when you look at the list of well-known trademarks, you see that until uh, um, a, a well-known name called Mother Dairy, if I'm not wrong, you see that all the marks that have been given the status of well-known trademarks before Mother Dairy, it has been so that the court has decided on particular grounds that the trademark has gathered a well-known status. So until then, it was all part of a hearing and providing evidences and a very time consuming process in terms of litigation as well. So it was only in terms of we saw that only when there were already services or products released under their brand name, and you could see that there was a lot of confusion uh, creating amongst the people. And when the big brands like Bajaj or Rolex, or where they have like transportal reputation, um, they say that we needed something that could where we could apply or we could be classified as a well-known trademark rather than going through a hearing. So after the 2017 rules were enacted, now the registrar holds power in terms of deciding whether a well-known trademark, a trademark can be given a well-known status or not. So they have to supply a few documents as per the rules 124 of 2017. And once it is when the registrar is satisfied, you will have that well-known trademark category granted to you. And also with respect to the trans-border reputation, I think one of those very important cases that we've seen is NR Dongre versus Whirlpool, where the court went on to say that Whirlpool has gathered a lot of reputation internationally as well as in India, where they have marketing over air conditioners, refrigerators, and washing machines. And it has been advertised internationally as well as in India. And when you think about the name Whirlpool, you see that these are the services or the goods that you associate with them. So when the plaintiff came out with the product that associated with a similar name, and you could see that uh, it infringed on the name of Whirlpool. So this was a passing of action that was um, bought by Whirlpool. I will explain what is a passing of action as well. Uh, I just wanted to uh, put across one of those important cases. Now everybody knows Louis Vuitton, and excuse me. So the trademark is a very, very reputed one, a luxury brand that's associated in France, and it's in case of this particular case, Louis Vuitton Dark is an example where it's a South Korean fried chicken restaurant that lost the battle in terms of the closing line, and the court obviously ruled in favor of um, Louis Vuitton, and stating that the logo and the packaging of the restaurant were resembling very much to the rest the clothing or the designer image. So these are one of those very important examples, though that is very difficult to imagine that Louis Vuitton would enter into something like fried chicken. But you see that a well-known status, as I said, becomes so substantial in the eyes of public that anything, any product or a good associating with their name would amount that they are investing or they are carrying out that particular product or service. So yeah, that is with respect to well-known trademark and having a trans-border reputation. Now, when you look at registration of trademark, you see two very important symbols everywhere, where R is your registered trademark and TM is your application has been filed. So the status is yet pending. So yeah, before you start off with the registration process, I think the most important thing that anybody has to do in terms of when you look at the registration process is the due diligence and the risk analysis that has to be undertaken before an application is filed. See, what happens is that once you apply and it goes to the examination stage by the registrar, you see that without doing prior search or in the registry or on the IP India website, um, you have filed for a registration of a mark where there's already in use, and by avoiding all of the uh, lag of time, you could simply do your public search beforehand. So that is one of the due diligence parts I was really, you know, emphasizing on, that you cover your bases before you file for an application. There's a part where you can do public search, and there's a part where you could obviously scan through the journal publication that comes out every Monday in the IP India website, and it is published by the registry. And you can see that it's listed according to the goods or services. Tomorrow, if, for example, I would say class 30 is associated with baking and baking goods like cakes or confectionaries or assorted items related to um, food. So if I had to start some name called a cake bakes or something like that, I would definitely would want to search under class 30 of the niche classification that is listed by WIPO, and you do a public search under class 30. So starting with the name cake bakes or containing the name cake bakes, you do that part of the prior search before you file for an application. So it also depends upon the kind of application that you do, whether it is a single application or a multiple class application. Are you also associated with goods, or it's a combination of services as well. So it depends upon the classes as well. Some people, if I say um, class 30, it's also with respect to the packaging part, the production part that comes under class 13 as well. So these are the multiple class applications that can be filed. Um, just a second. If Yeah, I'm sorry. Yeah. So yeah, I was saying application. So once you file your application in multiple classes or single classes, what happens is that the registrar looks over that particular application, makes if it meets all the grounds, then it's accepted, or it's conditionally accepted, where you need to satisfy with evidences and correspondence within 4 weeks of when the examination report is generated. So once that happens, um, it's published in the journal for a period of 4 months, within which an opposition can be filed by a person who's aggrieved by your application. So that is where the whole aspect of trademark infringement comes. So you see this part where it is advertised for a period of 4 months. So any person who's a prior user can file for a trademark infringement suit by seeing that the person has been uh, looking out to start a particular business in so and so goods or services. So that's the very important part in terms of journal publication. And then it moves on to the hearing, of course, and the trademark infringement suit, and where any of the remedies is dealt with in terms of an injunction or punitive damages or any sorts. So this is the a part of the registration procedure, and then of course you it's valid for it moves on to registration. It's valid for 10 years, and you'll have to renew it um, every 10 years. So that's the thing. And absolute and relative grounds for refusal of registration, um, as I said, it should not be obscene, or section 9 or 1 and section 9 2 uh, completely states in terms of the most important part in terms of any trademark registration is that it has to be distinctive. When you look at a mark, it has to be new or distinctive of the marks that has already been registered. So that is the main important category that we look for in terms of registrations. And a mark cannot be registered if there are relative grounds in terms of if it's as nature as to deceive the public or cause confusion, or it has it hurts the religious sentiments of any people, or it has scandalous or obscene content, or it is prohibited by the Emblems and the Names Act. So you also have prohibited trademarks list published by the registry, where, for example, Gandhi or Nehru is not something that you can register a trademark with. Um, yeah. So when you come to the aspect of distinctiveness, we see that what is distinctive in case of marks which have um, acquired secondary meaning. So these are marks that are very that are inherently distinctive and have acquired distinctiveness through secondary meaning as well. So these are marks that are descriptive. They might not have that much of distinctiveness in terms of qualifying for a registration, but they have gathered secondary meaning. So when I say secondary meaning, I think one of those very good examples are the case Living Media India Limited versus Jitendra Vijayan and another, where the court went on to decide that Aaj Tak are two individually descriptive names, and they cannot be monopolized by any single user. However, by virtue of their own extensive views and prior and extensive views, the combination of the words have gathered a secondary meaning where you associate that particular word in terms of a news channel. So also in terms of Apple, when you look at Apple, you see that the word is a very descriptive, very generic name, and it basically says that it meets the absolute grounds of refusal in terms of registration, where it's not at all distinctive, but it has gathered secondary meaning where through its products and services over the years have associated Apple as the phone and the MacBook market, right? So this is how marks that have evolved or gathered a secondary substance to their element can be qualified to register. So when we come to trademark infringement, now according to the section 29 of Trademarks Act, a registered trademark is infringed by an individual who, not being a registered holder or an individual by way of permitted use. So basically, it's an unauthorized use of 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 a person's of an authorized person's products or name or goods or services with respect of which the trademark is associated, and in such manner as to depict the use of the mark likely to be taken as being used at that particular trademark. So um, basically, it means that, and a registered trademark is considered to be infringed in the following situations, as I've mentioned, that if the mark is identical or deceptively similar. Number two, it causes confusion in the minds of the public. And three, it's a registered trademark used as a part of a trade name or a business concern of where the trademark is registered geographically, and if the trademark is advertised or results in an unfair advantage. So we also have to look at competitive markets and unfair competitive practices. And The last one would be the registered trademark is used in the material for packaging or labeling. So these are the kind of infringement cases that can happen. So, but most of the cases that we observe are in the lines of deceptively similar or identical, or can cause confusion in the minds of the public, right? So, in an action for an infringement of trademark to be undertaken, the plaintiff must be a registered owner of a trademark, and the defendant must be making a mark of a deceptively similar um, of the plaintiff's mark, and the use must be in relation of the goods or services the plaintiff has been associated with. So now this is very important, as people still file for a trademark infringement suit where they are not concerned at all. See, that is a different aspect where we have the brand has become a very well known brand in terms of being very substantial to the public. But in terms of a trademark, um, it has to be very very important that the use must be in relation to the goods and services with respect to where the plaintiff's mark is registered. So now the this becomes one of those very essential points, that in terms of how a trademark infringement suits are carried out. And most of the time, uh, because of this point, prima facie, the court rules in favor of the opposite party. So the use by the defendant must not be accidental, but must be in the course of trade. So this is one other category that can be grounds. So, in terms of a unregistered trademark, so no person shall be entitled to constitute any proceeding, prevent, or recover damages for the infringement of registered trademark unless there's an option of passing off. So it's a common law remedy, and um, yeah, where it does not give an explanation of what a passing of remedy is in terms of the Trademarks Act of 1999. But it's a common law principle which says that where the person has been associated with that particular brand or goods or services, and has established goodwill amongst the public, and that anything associating with that particular brand name would amount to confusion amongst the public. So, one other thing that I mentioned earlier is Whirlpool. As I said, Whirlpool had bought a passing off action against Ina Dongre for it to have gathered a very well known reputation across countries. And so, as one of the quotes says, the fundamental principle behind a tort of passing off is that a man is to not sell his goods under pretense that they are the goods of the other man. So basically, no cheating is what the whole principle of common law passing off states. And before I proceed to the essential aspects of passing off, I just wanted to mention about the period of limitation in terms of the Limitation Act of 1963. The period for limitation of any infringement suit is 3 years from the date of infringement. So this is the law in terms of how a trademark infringement suit is carried out. But however, if there are any new advancements or new facts to the case, then this category or the veil falls in terms of the period of limitation. And And yes, one other case that I really wanted to talk about was the case of Cadbury India Limited versus Neeraj Foods. It's a very, very old case, but the High Court of Delhi explained what is the difference between passing off action and trademark infringement under this case. So here it stated that trademark infringement, it is a statutory remedy, whereas the other is a common law remedy, and the use of trademark of the plaintiff is also a prerequisite in terms of causing an action for infringement, which is not necessary for passing off. And the registration becomes very mandatory in terms of a trademark infringement. Uh, and in passing off action, the registration of a trademark is not mandatory. Uh, also in terms of passing off action, the onus lies on the person who is bringing out the passing off action to prove that he has reputation, he has goodwill, and that any associated product or a service or an infringing product or a service would cause confusion amongst the public. So the onus is on the person who's bringing the passing of action. Here, it's not so as with respect to trademark infringement of a registered trademark, and that is the difference between the two. And this was very much established in Cadbury India Limited versus Neeraj Food Products. And there's three elements of passing off, popularly known as the classical trinity, in terms of how a passing off action works. And this is reputation, misrepresentation, and damage to the goodwill. So, as I said, these are three categories that the passing off action will look at in terms of priorities or the onus of proving their um, um, goodwill. So when we look at defenses against infringement, of course, we all can talk about grounds for trademark infringement and what brings in an infringement suit in terms of during the process of registration, during the process of opposition, and in terms of gathering a well-known trademark status. So when we look at defenses, we have fair use, prior use, no confusion or difference in essential features, marks used in different market, non-use by a mark by a registered proprietor, concurrent and honest use, parody and invalidated of registered mark. When you look at copyright, you also have a section wherein you have permitted areas of using fair use. It's the same with respect to trademark, where you can uh, use fairly, and in terms of prior use as well. So yeah, just a second. Are my slides moving?
Yes, ma'am.
Yeah, correct. So yeah, I was saying yeah. So prior use and one second. Yeah, no confusion or difference in terms of essential features. So one case that I would wanted to discuss is the SM Dichem Limited versus Cadbury. We've seen a lot of Cadbury cases today, but I found them interesting in terms of how the court went on to analyze the aspects of uh, deciding or factoring in their perspective in terms of how the case was decided. So it was in this case that the Supreme Court laid down in deciding a case of trademark infringement, and the court must, we went on to say that it must look into the differences in the essential features uh, that lay down is it. So one of the very important categories is there any special aspect of the common features which has been copied? Whether the dissimilarity of the part or the parts is enough to make the whole thing dissimilar, and whether there are common elements, should one not pay more regardless of the parts which are not common. So applying this test, it was held that the two marks were different in essential features and would not cause confusion in terms of the public, and therefore there were no damages involved. And however, we look at an essential feature in terms of two very similar marks, and where you see, if the intention was to deceive or cause confusion, then the infringing person would be held liable by the court. um, that is the case. And there are other in terms of yeah, just a second. Yeah, these are the few other cases in terms of Jollibee Foods. It went on to copy similar packaging in terms of the plaintiff, and the essential features were very similar. And though they were not associated in a particular product, the court went on to say that there is no way any confusion in terms of how the products are being associated with each other. So this was one of those few cases. And remedies, yeah. Are we running out of time?
No, ma'am, not at all.
Okay, yeah. So yeah, one other case that I really wanted to discuss is the honest and concurrent use as well, in terms of the defense for um, a trademark infringement. And when you see a particular mark that has been carried out, or has prior use from a very long time and has been established, or in a negligent but in an honest way, however, so you see that the court has been very kind in terms of granting injunctions or stopping that particular product or company to associate with that particular line. So one other important case in terms of that is Course India Limited versus Code. Um, it's a 1989 decision where the five factors were laid down in terms of determining the registrability of a trademark uh, owing to a trademark infringement suit. So the five-factor test that was laid down was the quantum of current concurrent use of the trademark in connection with the goods or the services, um, and the duration and the geographical area and the volume of trade. So this is one of those important points, and the degree of confusion that would likely to ensue from the resemblance of the marks. Um, Third is the honesty of the use of the product, and whether there are any instances of confusion that have in fact been proved, and the relative inconvenience that which would be caused if the marks were registered, subject to, if necessary, any conditions and limitations. So these are the five factors test that was laid down by um, the Code, the course versus Code. And one other aspect that I would wanted to tell you is, yeah, in the case of Daichim Cadbury, I think the facts was there was a class 30 confectionery and a chocolates class and a class 32 beverage and mineral water. The defendant was using the trademark picnic for chocolates, and it was already registered in 1977, in fact, and which had expired after 7 years and was not renewed. However, Cadbury's Picnic or Picnic was, registered in 110 countries and enjoyed trans-border reputation. So this was the facts of the Daichim versus Cadbury case. When we look at remedies, we have Section 29 and 30 of the Trademarks Act that deal with the infringement as a remedy against unlawful and unauthorized use of a trademark. And a trademark is diluted, with the distinctiveness of a famous mark is or blurred or tarnished by the association of a similar mark or a trait. So the principle of trademark dilution is it comes from or it stems from popular brands being or popular names being diluted by similar brands or carrying out similar practices in the same aspect of which the prior or the primary brand is carrying out. So, the Trademarks Act provides for civil, criminal, as well as administrative remedies in terms of trademark infringement suit. When we look at civil remedies, I think the first and foremost, in terms of uh, a remedy that is issued is the injunction, basically, where you prohibit somebody from a party, basically, into taking something into action by the court, and an injunction is given either of the parties. It's not only to the defendant. Whereas Moreva is very specific. It's only in terms of granting an injunction against the defendant in terms of carrying out particular action in terms of his goods or services or his company, basically. And we all know John Doe orders and Ashok Kumar, as we've called it here in India. And we have multiple cases in terms of how John Doe orders have been carried out. And one such case is the Eros International versus BSNL, where the court ordered a on a John Doe order on all those websites, basically restricting them from releasing a particular movie on their website. So this was filed for a movie Dishum prior to their release itself. So even with UTV Software Communication Limited versus Home Cable, the Delhi High Court issued a John Doe order against the cable operator who had allegedly telecasted a private version or a pirated version of Sat Khoon Maaf, and the court had ordered damages in terms of the remedy, and of course the permanent and perpetual injunction as well, where you permanently restrict somebody in terms of carrying out a particular business, and damages or accounts of profits where the person is the court rules in favor of um, each the party where the other party has to pay in damages. Now we look at criminal remedies, and the Act lays down a few sections where it can be carried out. Section 103, for example, the Act lays down criminal remedy for contravention of any trademark of an individual or entity, which lays down for a period of 6 months for imprisonment, which also might extend to 3 years. And Section 104, which penalizes about penalties that need to be provided as a result of um, an infringement suit, and it mentions a fine of 50,000 rupees, which can be increased up to 2 lakhs if somebody is found to transgress the trademark rights. And of course, with respect to the seizure of powers of the person liable for infringing, can be carried out. But this is respect to reasonable grounds, as proving in terms of how the police carries out for proving infringement. And of course, we have administrative remedies, opposition against similar mark. I think the most basic in terms of how an infringement suit carried is out is the trademark publication that happens for a period of 4 months, as I have mentioned previously, and rectification of a registered trademark. So, an aggrieved party can file for rectification or cancellation of registration if threatened with a lawsuit, and if that person believes that the mark is widely similar or uh, deceptively similar in terms of causing confusion. And it also it can be that a mark has been remained in the registry, and the registrar hasn't removed it, and so it has expired without considering its similarity in terms of new marks being registered. You can also um, rectify that particular trademark. So also with respect to recordal or documentation with the customs to prevent import or export of goods bearing the infringed mark. So the customs duty plays a very important role in terms of infringing or pirated materials. Especially you see these merchandises where a lot of footwear, bags, um, sport related goods are pirated versions of the same. So, lastly, I wanted to just give out a few very important decisions that have been recently um, decided in terms of the trademark infringement. And I'll go on to say the what the court specifically said in terms of these cases. And this was a case of the car price. And although the court stated that the price had goodwill in terms of international markets, especially in Japan, but the court observed that the sales weren't as much as what they had in Japan or other countries, and the advertisement had stopped prior to 2006, and sorry, prior to 2001. And this in turn, it would show that either lack of goodwill or in the domestic market, or lack of knowledge and information of the product amongst a significant section of the Indian population. So this was what the court went on to decide in terms of a trademark infringement suit, where it had not gathered that much of goodwill in the Indian markets. Britannia Industries Limited versus ITC and others. So this is a recent decision in the Delhi High Court, and it elaborates upon the infringement of a trademark, which is very deceptively similar and may create confusion. So the court went on to say that the passing off has to, it's a common law principle, where it has to be viewed from the perspective of the customer. who wants it to purchase the product, and whether he, having bought the product of the plaintiff, likely uh, would cause confusion. So as I said, three main important categories of passing off action is um, damage to goodwill, misrepresentation, and establishing goodwill. So these are the three categories. And with that, I would want to end my presentation um, with regards to how the trademark law has evolved in terms of uh, prior to the British, as well as how what we see today and what transborder reputation means, and the infringement suits that can be carried out and the defenses associated with it. Thank you.
Thank you so much, ma'am. And we have a few questions from the participants.
All right, yeah, please.
Yes, ma'am. So the first question is, what authority deals with the trademark infringement in the international scenario?
In terms of international scenario, it all depends upon the kind of infringement suit you bring upon, whether it has international registration here in India. As I said, common, passing off action would be the principle guiding this. And if the infringement has happened within the jurisdiction of India, then the jurisdiction at India would be deciding that particular matter.
The second question is, what would be the future of trademarks, especially at a time when the world is moving digital? And is there any need to change the existing laws on trademarks given the changing circumstances?
So what I think is a changing world, as everybody is seeing, in terms of how each brand is becoming bigger by the day. But I don't see any essential changes that needs to be in terms of course there are loopholes in, as I said, the well-known trademarks haven't been clearly defined. So I think the most important part for us, in terms of moving in the future, is defining the terms that we already have, not vaguely represent each term.
Okay, ma'am. The next question is, do you think that the Indian Trademark Infringement Act is efficient enough to penalize foreign companies or companies situated outside of India?
I think, as I said, it all depends upon the or principle of the case, the facts and the merits associated with it. Of course, it's I wouldn't say uh, the act is very efficient in terms of managing foreign companies, especially when we saw the Christian Louboutin case where the Red Soul, whether it would be given a registration. So the court went on to say that no, a single color cannot be given that status where our statutes say that combination of colors. So this is a very tricky situation as well, where Christian Louboutin has already acquired such a big name. Um, we have yet to see where we head in terms of these loopholes. Yes.
Okay, ma'am, thank you. Those were the questions. Thank you so much for joining us today and enlightening the audience about the trademark laws in India. It was an honor to host you. The committee looks forward to have more sessions addressed by you in the future. Thank you once again.
Thank you. Thank you so much. It was a pleasure. And I hope we associate further um, in the coming days. Thank you. Thank you for listening.